Hello, good afternoon, and welcome everyone. We're so glad that you're joining us today for what will be a very helpful and informative webinar. My name is Sam Farkas. I am an attorney and the Vice President of Instruction here at BARBRI. I want to welcome you to this webinar entitled How to Succeed in Law School. That's something that's probably on a lot of your minds. Today, you're going to hear from a true expert on this topic. And just a quick housekeeping note here at the start, feel free to drop any questions that you have in the Q&A box as we go. We'll make sure we reserve some time at the end to answer as many questions as we can. I'm delighted to be joined by someone who is not only the Dean of Emory University School of Law, but also a professor of law. His areas of expertise are civil procedure, business associations, and complex litigation. He's authored 17 books and is the only person to serve as a contributing author on 2 multi-volume treatises on federal jurisdiction and practice. He's an award-winning teacher and someone who's helped about 500,000 people pass the bar exam. Now, I know sitting here at the beginning of law school, the bar exam probably feels a long way off, but in order to get to that bar exam, you're going to have to get through some final exams along the way. So with that being our mission for today, it is my distinct pleasure and honor to introduce you to Dean and Professor Rich Freer, who's going to help make you more successful in law school in about an hour. So with that, Dean Freer, I turn it over to you.
Sam, thank you so much for that nice introduction. Thank all of you for being here. And I want to say congratulations. That's what I want to start with. Congratulations. You should never lose sight of this. Think about how you dreamed about going to law school and you worked really hard to get to law school. And now you're here and you deserve to be here. First year can get a little stressful, but never doubt yourself. You belong here. Congratulations. I got to tell you, being a professor is the best job ever. And it's all because of the students. We get to know the students. And then after you graduate, we stay in touch and we follow your careers. And yes, we become friends with many former students. In fact, I had a former student stop by my office, about a week ago. And we got caught up and we talked. And then he got really serious with me. And he said, Professor, I've been thinking about this and I want to tell you something very important. And he said, if I had 1 hour left to live, I would spend that 1 hour in your classroom. Well, I got all choked up. I was overwhelmed. But then he said, because the way I remember it, you can make an hour seem like forever. So that was the deal. And hopefully today's session will not seem like forever. Let's talk about this first year of law school. It's exciting. This is the academic big leagues. And it can get a little stressful, but I think we're going to de-stress the first year to a degree. And we're going to do that by understanding 2 things. One is, why is law school different from college? And the other is, how is law school different from college? The why is really pretty easy. Here we're being educated and trained to practice a profession. Now, that was not true for most of us back in college. Most of us were liberal arts majors, and we were never going to make a living by using whatever it was we majored in college. But in law school, it's different. We are being trained for our professional life, and it's really important to understand. Law is a problem-solving profession. That's what it's all about. No matter what area of law you go into, no matter who your clients are, they hire you to do one thing, and that is solve their problems. And that is why law school is the way it is. This is a profession dedicated. You are dedicating your professional life to solving other people's problems. And that's a noble calling because it is a service profession. Now, when we think about it, in college, for most of us, certainly the liberal arts majors, and I was a sociology major, so I knew I had to go to law school if I ever wanted a job. But when we think about it in college, learning the material was an end in itself. The goal with exams and papers really was to demonstrate to the professor that we had learned the material. law school is different. Now, make no mistake, our job is to learn the material, but that's not enough. It is not enough in law school simply to demonstrate to the professor that you know the material, that you know the relevant law. Your job in law school is to demonstrate that you can use that material, the legal doctrine, to solve problems. And those problems are posed by a fact pattern. Why do we do it this way? Because that's what lawyers do. So realize you're learning a lot of law. That's important. But essentially, you don't get a lot of credit just for knowing it. You've got to show that you know it, but you've got to do it in the context of an exam, which means you're going to be problem solving. More about that in a minute. That is why law school is different from college. We're being educated and trained for a profession. Now, how is law school different? Well, you already know this stuff, but one of the things, the materials we study. In college, usually we read texts. We had textbooks, and those kind of told us what we needed to know. In law school, we don't really have textbooks. We have what are called case books. Why? Well, notice our case books generally don't have a lot of text to explain what the law is. Usually it's raw materials, and the raw materials usually are cases, opinions written by judges deciding real world disputes. In addition, there are statutes and restatements and federal rules of civil procedure. Why do we do it this way? Why do we learn the law by using raw materials? Because those raw materials are the tools that lawyers must be able to use. But the biggest difference between law school and college is the way we grade. For starters, most courses, 100% of the grade is on the final exam. That was not true in college. We had quizzes and things that allowed us to know kind of where we stood. But here, in most cases, the whole grade is on the final exam. And that's nerve-wracking. That's a Pepto-Bismol moment. Now, that means that when you go into exams, you are going to be nervous. But look around the room. Every single person in that room is nervous. The way to avoid the anxiety when those exams roll around is to do smart work in the meantime. And there is so much we can do to lessen that anxiety. Now, let's talk about that because the exam, we know, gosh, that's a big deal. Well, first of all, on the procedural aspects of the exam, your professor is going to tell you everything you need to know. It's probably in the syllabus. But things like the length of the exam, the format, are there essay questions? Are there word limits? Multiple choice? Is it open book? All of those things are fair questions, and your professor will tell you all of those things, including what does open book mean? Does that mean open casebook, or does it mean anything at all, including the internet? Your professor will decide those things, and those are fair questions. Your prof's going to tell you all the procedural stuff. Now, on the substance for the exam, as you study, keep in mind, our job on the exam is not simply to show the professor that we learned the material. We do have to do that, but we have to be able to use that material to solve a problem. And because of that, on an essay exam, you are very unlikely ever to get a question such as, what are the elements of the tort of battery? Or what is the difference between in rem and in personam jurisdiction? You're unlikely ever to get a question like that in a law school exam. Why? Because in the history of the world, no client has ever asked a lawyer that, ever. No client has ever run into a lawyer's office and said, tell me, I gotta know, what's the difference between in rem and in personam? Instead, your client is going to give you a fact pattern. The client will tell you a story. And that's why law school essay exams are not straightforward questions about what the law is. They are fact patterns. And you, as a problem solver, need to determine what facts are relevant, You apply the law to those facts, and then you reason through to a conclusion. You solve the problem presented by the fact pattern. So, yes, you do need to know the elements of the tort of battery, but not in the abstract. You have to be able to identify those elements in a fact pattern. That's how it's different. It's not just do you know the law, it's can you apply it to a fact pattern. And let me say something radical. Most professors will disagree with this, but my theory is that on an essay question, you really don't get a lot of points for simply knowing the law. You do need to know the law. You do need to state the law. But the points you earn on the exam largely come from applying that law to the fact pattern and then reasoning through to a conclusion. So we must find facts that relate to the law that we know. That's where the points are going to be on the exam. Now, to start off, of course, we must know the material. Absolutely. We're going to learn a lot of law. Now, in this little lecture today, we have a handout. I think you had a PDF of it. You may have a link to it. And it's not the most important thing in the world, but if you have it, let's take a look at it. You'll notice right off the bat, it says 4 suggestions about learning the material, because obviously we're learning a lot: torts, contracts, criminal law, property, civil procedure, whatever it is. Now, I have 4 suggestions, but let me emphasize, that's all they are. That's all they are. You're going to find your own way of learning, but I do have these, and they're common sense. First, read the assignments. Absolutely always try to get the reading done. I know it's hard sometimes. I know life intrudes. That's fine. Do the best you can. And I also know that when you read those cases, you're gonna look at your friend and say, "What?" And that's okay. That's okay. Give it a shot. Give it a try. And that leads to the second suggestion. Always, always, always go to class. If you can, always go to class. Even if you're unprepared, it is not the end of the world if you get called on and you say, "Professor, I'm simply not prepared." That's fine. There's nothing wrong with that. Go to class, and in class, focus. Focus on what? Well, first of all, you're going to learn what those cases mean. You read a case and you thought it said ABC. But then when the prof explains it and talks about it, it turns out it was more like XYZ. So this is where you're going to learn what the cases mean and the rules and the statutes and the restatements. And professors, secondly, I always want to say this when you're going to class, not only focus on the discussion of the cases, but absolutely, profs will almost always give you a hint of what the exam questions will look like. Write down every single fact pattern that your professor raises. So, for example, you read a case where the facts are a certain way. Now, in class, the professor changes one of those facts. Folks, that is a potential exam question. You write down every single one of those, and you take advantage of what the prof tells you about how to resolve that. Third, so we're reading the assignments, we're going to class. Third, you must review. Folks, we cannot cram in law school. You simply cannot do it. There's too much material. I think there are 2 kinds of reviews. First is one that very few students do, but I'm going to suggest give it a try. It is essentially a daily review. Now, this is not a big deal, but at night after classes, take maybe 5 or 10 minutes for each class. Go back through your notes and simply write yourself a little note. Just jot it in about what the prof thought was important in that class. And I suggest that you do it that evening because it's fresh in your mind. Turns out you went in there and you thought ABC was important. Turns out it's XYZ. Why? Write that down. I think it's a good idea. Just try it. The other kind of review that everyone does is periodic review. And most people call this outlining. And there's nothing wrong with the term outlining. I prefer the term distilling. And the way I did it, and again, these are simply suggestions. You're going to have to find your own way. But here's how I did it. At the end of each topic, like each Roman numeral in the syllabus, that weekend, I would find time to distill it, synthesize it. So I don't do this all the time. It's at the end of a topic. And I would sit down and I had my notes here, including those little notes to yourself. And you have the case book here, and you may have a study aid. And there are a lot of great study aids. And let me say, the BARBRI 1L Success Program absolutely has so many great resources, including lectures. And West Academic has so many great study aids. So you sit down, and your goal here is to create a new document. Do not rewrite your notes. This needs to be short, distilled, a summary. Get that law down. And I suggest that there may be topics on which you spent 2 weeks in class that can be reduced in this outline, this distillation to, I don't know, 2 or 3 pages. The length of that depends on your own comfort level. There's no right way or wrong way to do this, but I believe you absolutely must do this periodic review. I suggest you do it after you finish each Roman numeral in the syllabus. And the deal is, I would not put it in my outline until I really understood it. So I'm not simply rewriting notes. I'm saying, okay, what does that mean? What does purposeful availment mean in this? And then you put it down. And the brilliance of this system is this: when exams roll around, you're not going back through pages and pages of notes, and you're not going through the casebook. You've done the heavy lifting. And you only have to review a couple of pages, maybe, for each Roman numeral in the syllabus. You see, you've made those connections. That is how you lessen anxiety in December. To have less anxiety in December, you do the work in October and November. And that's the heavy lifting, that distillation. You got to do it sometime. You're not going to have time to cram it all at the end. Do it as the course unfolds. And I cannot tell you how much confidence that's going to bring you going into exams, because you've done that heavy lifting. Now, as you outline, if something is unclear, use a study supplement. Again, 1L Success from BARBRI, West Academic Study Aids. And folks, don't forget office hours. I said a while ago, being professor is the best job. It is. But the only bad part is it's kind of lonely, because often students don't go to office hours. It's kind of like waiting for the Comcast person to show up. So go to your professors. That's what office hours are for. Fourth thing we ought to do, in addition to reading the assignment, going to class, doing the review, work on practice questions. Professors might provide them. Certainly the commercial sources I've just mentioned from BARBRI and West are going to have those materials. It builds your confidence. If you have sat down and written out essay answers to a couple of questions, a few questions before exams, you go in there knowing that you can do this. Now, there's a lot to do in law school. It's a lot of work, but it's law school. It is not law prison. You can and should have a life, but realize you're training for a career in a profession that takes discipline. Discipline's a good thing, and we're learning it in law school. Time management is important. Of course, you're going to go to a football game here and there. Of course, you're going to watch the baseball playoffs. Of course, you're going to be with your friends. You live your life, but you manage your time well so that when you are working on school, you're getting the right things done. Now, what is this distillation or outline kind of thing? What does it look like? There is no right or wrong way to do this. Everybody's going to do this differently. But on this handout at the bottom of that page, I have an example of what one might look like. And this, I must admit, is very, very, very skimpy, but it just gives you an idea. And I want to talk to you about this and walk you through it, because I think there are some lessons to be learned here. This one happens to come from civil procedure. And of course, there's no need for a show of hands. Civil procedure is everyone's favorite course. Absolutely, no question. And what we have here is a distillation for subject matter jurisdiction in Civ Pro. Now, remember, federal courts can only hear certain kinds of cases. And one of those kinds of cases they can hear is called diversity of citizenship. Now, after you study all the cases and all the rest of it in the diversity of citizenship material, what do you take away? And again, everybody's outline is going to look different. This is just a suggestion, and this is very sparse, I must say. But take a look at what we have here. Diversity of citizenship jurisdiction, there are two requirements. Absolutely, there's no question this is right. One is the complete diversity rule. Now, be careful about that. That means that no plaintiff can be a citizen of the same state as any defendant. Now, notice how precise that is. You've chosen a profession where words matter. Do not say everybody's got to be diverse from everybody else. That's not the rule. No plaintiff can be a citizen of the same state as any defendant. So that's one thing. And then the other thing is the amount in controversy must exceed $75,000. So there are two prongs to diversity. Now, how do we determine citizenship? Because we've got to meet the complete diversity rule. So no plaintiff can be a citizen of the same state as any defendant. How do we determine citizenship? Well, notice what it says. For a human being, a U.S. citizen, it is the U.S. state of her domicile. So a U.S. citizen is a citizen of the state in which she is domiciled. Now, how do we establish domicile? Well, there it is. Two requirements. Physically, you've got to be present in that state. And secondly, mentally, you must form the intent to make that your permanent home or your home for the foreseeable future. Now, folks, let's psych out the exam. When you're doing this distillation, ask yourself, of those two requirements, which one is going to be more difficult on the exam? And everything that is a little more difficult because it's inherently ambiguous, you put a star next to that. You have to meet both of these. But seriously, is the physical presence in the state going to be a difficult issue? Probably not. I mean, she's either there or she's not there. I mean, that's not going to be all that tough. The tougher part is likely to be the intent. Did she form the intent to make that her permanent home, her home for the foreseeable future? Now, knowing that that's inherently ambiguous, you go into that exam looking for facts. What facts show her intent? For example, maybe the exam question says she bought a house in that state. She took a job in that state. She registered to vote in that state. She joined a civic organization in that state. She qualified for in-state tuition in that state. She joined a faith community there. What did I just do? I gave us 6 facts that are relevant to her intent. On the exam, everyone knows the rule. Knowing the rule is not the only goal. Apply facts to it. If there are 6 facts that are relevant, your grade depends on how many of those facts you saw and applied. So how many of those 6 did anybody see? Now, let me tell you to relax, because nobody ever gets all of them, ever. But the clue is this. Go into that exam aggressively. You know that in this area, it's more likely that intent is a little more amorphous than physical presence. So you're looking for those facts. Read aggressively. Don't be afraid of an exam. You go in and you take charge of it. Now, the rest of this distillation are just rules, other rules in this same area. Corporations, a citizen, possibly of 2 states, the state of incorporation and the state of its principal place of business. And you know from the Hertz case what that means. Principal place of business is the nerve center where the corporate decisions are made. And the rest of this is simply laying out the rules. Your outline may be longer. This is awfully skimpy, I must say. But the point is, a distillation. Don't rewrite your notes. Distill, distill. And that's what you have, kind of a checklist mentality. And there may be an area where you need more notes. Great, do it. But you also psych out the exam. Where are the inherently ambiguous things where I know the facts are going to be especially relevant? Now, let's flip this paper and let's go over to the back side. And it asks, and it says that we'll have 6 suggestions about exams. And that's absolutely right. Let me give you 6 suggestions. Again, these are not rules. These are just suggestions. That's all. You do what works for you. But we're talking here about essay exams. Number 1, budget your time. Law school essay exams are usually pretty time intensive. Your prof will probably give you time suggestions. Now, that is a very important proxy for how many points there are. A 30-minute question will have roughly half as many raw points as a 60-minute question. So if you spend 45 minutes on a 30-minute question, you are not helping yourself at all. There's not 45 minutes worth of points there. This takes discipline. This takes practice. You got to get to that 30-minute mark and say, well, okay, I might go over a little bit, but I got to get this one wrapped up and get on to the next. Takes practice. Do practice. 2, I suggest very strongly that you address only one essay question at a time. There are often more than one essay question, and often the essay questions have subparts. My strong suggestion is you do question 1 with all of its subparts. You finish it completely, and then you go to question 2. I've had students who read the whole exam through, and that is a complete waste of time. When you're focusing on question 1, what is in question 3 is not relevant to you. I would do it one at a time. Number 3, essay exam questions. I would plan to read each question twice. And again, some people do it this way, some people don't. Find your way. The first time you read it, I suggest it's kind of quickly, like you'd read something online or in a magazine or something. The point here is to get the gist. What is this about? In torts, is it about an intentional tort or negligence? In contract, is it about formation or about breach or about remedy? What is it about? And in that first read, focus on the call of the question. That is where the professor tells you what she is asking you to do. Now, you have the call of the question. You know what you're being asked to do. You have the gist of the question. Your mind is already working. Oh, this is an intentional tort. Now, go back and read it the second time. Now, more slowly, more carefully, read aggressively. You know this is about, let's say, contract formation, whatever it's about. Read aggressively. And a good habit to get into is this. For each fact, ask yourself, why is that there? Why is the professor telling me that? It's usually there for a reason. Sometimes facts are just there for no reason. But your job, in part, is to figure out what's relevant, what's not. But be aggressive about it. Number 4, and I think this is hugely important, but again, find your own way. For every issue in an essay exam, for every issue, you've got to do, in my opinion, IRAC. State the issue, apply the rule, state the rule, state the rule. Apply the facts to the rule and come to a reasonable conclusion. IRAC, I, the issue. That's usually going to be pretty clear. R, state the relevant rule. You must know the law. State the relevant rule. Then apply the facts. Then come to the conclusion. I strongly urge you not to start with a conclusion. I think you keep it mechanical. Keep it mechanical. And let me suggest some magic words. I have 3 magic words for you when you're answering an essay question. We've already stated the issue. The 3 magic words are under, here, and therefore. What do I mean? The word under forces you to state the rule. Under the common law, the tort of battery consists of blah, 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 whatever it is. Here, H-E-R-E, not H-E-A-R, forces you to apply the facts. Here, the facts are X, Y, Z. So you've just stated the rule. Now you've stated the facts. You apply those facts to the rule, and then therefore is the magic word to force you to come to your conclusion. Under, state the rule. Here, state the facts. Therefore, come to your conclusion. Relentlessly mechanical. Let's take a quick example from civil procedure. We know that in serving process can be served by a non-party who is at least 18 years old. Now, let's say that on the fact pattern, process is served by a non-party who is 17 years old. Every single person in the universe knows that that's no good, but not everyone will get credit on the exam. Why? Because a lot of people simply skip the steps. For example, somebody might say, service is no good because the process server is too young. In my book, that is 0 points. It's right, but it's 0 points. You haven't told the professor why. How should you do this? Relentlessly mechanical. The issue is whether service of process is good. So what do? Under the FRCP, service must be made by a non-party who's at least 18. Now apply the facts. Here, the process server was 17. Now go to your conclusion. Therefore, it's no good. Do not jump to the conclusion. There are points there for every step. Be relentlessly mechanical. Number 5, on an essay exam, expect ambiguity. Now, on almost every exam, you're going to get some easy mechanical issues like the one we just did about service of process, but some are going to be tough. Things like duty and proximate cause and negligence, personal jurisdiction in Civ Pro. You like ambiguity because it gives you a chance to show off. And what you got to do here is analogize. Again, you've read a case where the facts were A, B, C, and it came out this way. Now on the exam, the facts are A, B, and L. And you have to analogize. Well, it's kind of like that case where the result was this. On the other hand, there's a possibility that that fact L makes a difference. And then you argue it both ways, come to a conclusion. The conclusion is not nearly as important as the process. Don't let ambiguity scare you. Don't let that scare you. And that's why when you go to class, you write down every single fact pattern that your professor gives you, because those are all previews of exam questions. And number 6, on the essay exam, I propose that you allocate 1/3 of the time to outlining and thinking through your answer. And what I mean there is on scratch paper. So you take your pen, your pencil, whatever it is, and scratch paper, and you're writing it out. You're working it out in your head. A lot of students get in trouble by writing too early. This takes discipline. This takes discipline. But in that first, let's say we have a 45-minute question. In the first 15 minutes, you're sketching it out. You're figuring out, why is that fact there? Why is that fact there? Why is that fact there? You're tying up the law and the fact. And you map it out where it's going to go. And then you have roughly 30 minutes to write it out. And it takes discipline, but you've done the thinking. You want to do the thinking in advance. And again, try this in practice. Now, I want to say this about exams. Relax. Relax. First off, you are going to know the law. You're absolutely going to know the law. You're working hard on that. You have study aids. You've got your classmates. You have your professor. You have class. You're going to know the law. The exam on the essay side boils down to a scavenger hunt. Make it fun. You're looking for facts that are relevant to this issue or this issue. Gee, is that about formation of the contract? Gee, is this about a criminal intent? Whatever it is. Now, let me show you what I mean by this. Let's do a hypo. Let's do a hypo. This is not a pop quiz, but let's do a hypo. And this hypo, again, from Civ Pro, and this is about personal jurisdiction. And it asks for a constitutional analysis of personal jurisdiction of a fact pattern. This is under our old friend, the International Shoe case. Now, The exam might ask a statutory issue like whether the long arm applies, but look, this is going to be simply about whether personal jurisdiction here would be constitutional under SHU. Let me show you where it says a hypo. What I have there is a checklist of international SHU. In my opinion, international SHU boils down to 3 steps. Number 1, is there a contact between the defendant and the state in which the defendant's being sued? Is there a contact? Well, there are 2 elements that go into that. First, there's got to be purposeful availment. The defendant must reach out to state X in some way. And secondly, it's got to be foreseeable that the defendant could get sued in state X. Those are factors in determining whether there's a relevant contact under SHU. Now, let's say there is. The next question is relatedness. So yeah, D does have a relevant contact with state X. Now, the question is this. Does the claim, that assertion by the plaintiff, the claim, what the plaintiff is suing about, does that claim arise out of or relate to that contact? We just said there was a contact between D and state X. Does what the plaintiff is suing for arise out of or relate to that contact? If so, if the answer is yes, then it is a case of specific personal jurisdiction. If the answer to that question is no, gee, yeah, the defendant has a contact with the forum, but plaintiff is suing about something that happened somewhere else, then that's not specific jurisdiction. And the only way that would work would be general jurisdiction. And you know what general jurisdiction means. You could be sued in that state for a claim that arose anywhere in the world. And generally, there's general jurisdiction only where the defendant is at home. But we're going to leave that to one side. Let's say it is a specific jurisdiction case. So what plaintiff is suing about arises out of or relates to what the defendant did, the defendant's contact with the forum. Now, you have to go to the 3rd step. Because in specific jurisdiction, not general jurisdiction, but in specific jurisdiction, you must assess whether the exercise of jurisdiction would be fair. Fair play, reasonableness, and there are 5 fairness factors. And you're going to know this going in. One is burden on the defendant. Defendant's always going to say, I don't want to go to state X. I don't want to travel. State X's interest. The forum state where this defendant's getting sued might have an interest in providing a courtroom for this plaintiff. Now, why are we going through these? Because we're going to read a fact pattern and we're going to be looking for all of these. Third, the plaintiff has an interest, maybe. The plaintiff is suing in this state and really has a big interest that it be here and not somewhere else. We're going to look for facts there. Fourth, efficiency. What is that looking at? Well, gee, is state X an efficient or convenient place for this litigation? I mean, for example, where are the witnesses? You know, if we're going to go to trial, where are the witnesses? Are they in state X? Where's the evidence? Is it in state X? Then that helps us show fairness of jurisdiction. And then the court always throws in shared social policies of the states. And, I've taught Civ Pro for over 4 decades, and I've never been sure what the court meant by that. But if your prof has a theory on it, absolutely use that. And you might also want to drop me a note so I know what it means. Now, let's look at a hypo. Remember on the fairness factors, nothing is determinative, none of those. So you must walk through all of them and not simply mention them. You've got to apply facts to them. That's where the money is. So we're going to read this fact pattern. And we're going to figure out what facts are relevant to, to contact, purposeful availment, foreseeability, relatedness, all these things. Let's look at the hypo. D raises horses in Kentucky. D, we already know, is going to be the defendant. D is going to get sued. D raises horses in Kentucky and sent a horse, all right, to participate in a prestigious horse show, all right, at a new municipal arena in state X. I wonder why that's there. Does that matter? Scent, prestigious horse show, new municipal arena. So anyway, Dee sent this horse to State X. Now, what happens? Dee did not attend the show because she was to attend another show in Europe at the same time. Why is that there? Why is that fact relevant? But Dee ensured that her horse farm would be advertised at the show. She also requested police protection for the horse at the show. Now, at the show, something startled the horse. The horse went berserk and ran into the crowd. The horse trampled plaintiff, who is one of the police officers serving as part of the security detail. That's right, she asked for police protection, so this was one of the officers. Plaintiff suffered serious and permanent physical injuries requiring lifelong treatment. P sues Dee in State X, not Kentucky, State X, seeks damages in excess of the liability insurance coverage that Dee had arranged when she accepted the offer to show the horse. So this is a big case, more than insurance coverage. Okay. Would the exercise of in personam jurisdiction over Dee and State X be constitutional? We're not going to talk about a statutory issue here, long arm and the like. There might be one on your exam, but is it constitutional? This is not one of the traditional bases under Pennoyer. So obviously it's international shoe. Let's do the shoe. We're going to do the shoe. First, what facts in this fact pattern demonstrate that the defendant purposefully availed herself of State X? What shows that she reached out to State X? Well, let's see. She sent the horse there. That's important. This is not a stream of commerce where she sent it to some other state and the horse galloped into State X. She sent it to State X, reaching out to State X specifically. All right. What else? Oh, she advertised. She advertised in State X. She's availing herself of the market in State X. What else? Well, let's see. She requested police protection. That's availing herself of the state power there in State X as well. So yeah, she is purposefully availing in several ways here. What else? Is there anything else that shows purposeful availment? Well, I got to tell you, I got to admit something. This was on an essay exam. It was a much longer fact pattern, but this was the core of it that I gave years ago. And one of the arguments I got from a student was on the exam that it's relevant that it's a prestigious horse show. Prestigious horse show. Why does that matter? Well, the argument, and listen, none of these is a deal breaker. These are we're just trying to pick up points, as many as we can. And this does not make or break you, but the argument is, look, this is not some lousy horse show. This puts her at the pinnacle of the profession, and that shows more of an outreach. Now, I don't think that's a big deal, but it's creative and it's worth thinking about. What else? Well, what about foreseeability? What in this fact pattern indicates to us that it's foreseeable that the defendant might get sued here for something that goes wrong with the horse? Well, let's see. Oh yeah, where is the horse show? In a new municipal arena. It's not in somebody's backyard. It's at an arena. What does an arena imply? Big crowd. You got a big crowd, you got a horse, might have a problem, might startle the horse. New municipal arena. What other fact shows that litigation in State X would be foreseeable? Defendant bought liability insurance. When the defendant, notice the next to last line in the fact pattern, when the defendant agreed to send the horse there, the defendant thought, oh, I might get sued. There might be a problem with the horse. Let me get insurance. What does that show? Foreseeability of litigation. Folks, when you're reading, you circle these facts. And then in that 15 minutes of a 45-minute question, when you're outlining where you go, you collect all these facts. These are about purposeful availment. These are about foreseeability, etc. Now, let's say there is a contact. Sure, looks like a contact. Absolutely. Purposeful availment, foreseeability. What about relatedness? Does the plaintiff's lawsuit arise out of or relate to what the defendant did in the state? Absolutely. The defendant sent a horse into the state. The horse trampled the plaintiff. Bingo, relatedness. So what does that mean? Specific jurisdiction. And what does that mean? Fairness factors. First, burden on defendant. Defendant's going to say, oh, I don't want to have to go to state X. That's a long way from Kentucky. What fact is relevant here? Notice the third line of the hypo. Defendant did not attend in state X because she was at another horse show in Europe. What does that tell you? Defendant can travel. Defendant can travel. So, hey, going to state X shouldn't be a problem. What else? What else are we looking at for fairness factors? State X's interest. Does the state have an interest in providing a courtroom here? Yeah. I mean, for one thing, plaintiff is apparently a citizen of the state. For another thing, the plaintiff is a police officer. The plaintiff is somebody who serves the state. That's why that fact is there. Every fact, why is it there? This is a police officer. That's relevant to state X's interest. Notice it's also a new municipal arena. Maybe we can argue that, gee, state X doesn't want new municipal arenas to be places where people get trampled. So maybe there's a state interest there. Now, I know we're seeing things here that you didn't think of. No worries. Nobody in the history of the world would get all of these in exam conditions. Perfection is not an option. We're just people. We're just people. Get as many as we can. Now, what else? Efficiency. Oh, one other thing about I must say, one other thing about the plaintiff's interest. Look at that. She has serious permanent injuries. That's the plaintiff's interest for sure, right? Is the plaintiff interested in suing in state X? Yeah. First of all, that's where she lives, apparently. Secondly, she has serious permanent physical injuries and needs lifelong treatment. She can't go to Kentucky to sue this person, or at least that's the argument. Efficiency. Where are the witnesses? If we go to trial, everybody who saw anything is in state X. Where is the plaintiff? State X. Where are the medical records? State X. Shared social policies, I don't know what that means. But notice, make it fun. It's a scavenger hunt. Nobody gets all of those facts. Nobody. You go in there, you know the law. Be aggressive, look for the facts, come to a reasonable conclusion. But folks, when you go into those exams, believe in yourself. You have succeeded at every step. You're going to succeed here. Don't let this scare you. Everybody's learning the way along, and you're going to be ready. But this just a hint on getting ready for those exams. Again, nobody's going to get all of the facts, but if we practice and we know what we're looking for, we're going to get more than we otherwise would. So I'm very excited for you. And at this point, why don't we turn it over to some questions?
Sounds great. Thanks so much, Dinker. That was great. So we have one question here. This person asks, I have issues coming up with my own variants on fact patterns. Would you have any tips on how to come up with relevant fact variants, the core concept, and how they apply situationally? For example, would specific personal jurisdiction be less likely if insurance would not have been purchased due to the foreseeability factor being less apparent?
I have taught CivPro all these years. I have a case book and I have a treatise and I have a West study aid in CivPro. And I don't know the answer to that because I can tell you personal jurisdiction is one of those things going in, kind of like negligence with duty and proximate cause, that the answer is going to be arguable. And I think it's very difficult in most cases, not to say every exam question, but in most cases, it's very difficult to say, golly, if we change this one, that it'd be a different result. So I don't want to, I'm not playing games here, and I'm not trying to avoid the question. I think it's a great question, and it just goes to the importance of playing the facts in. And you know, maybe it's important, maybe it's not, but it's certainly worth raising. So I love the question, but just get used to the fact that in some areas in the law, there's no clear answer. You always want to come to a conclusion. But I'll tell you, on a PJ question, it's kind of like long division. You might get the answer the professor does not agree with. That's not all that important. What's important is you showed your math. You showed how you got there. That's the key. Don't burden yourself by getting the right answer. Now, on some things in essay questions, there is a right answer. The 17-year-old process server, that's a problem. And listen, you go into those exams, you get a mechanical issue like that, you nail it. Boom, 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 every point. Don't jump to the conclusion, gee, the guy's too young. Doesn't help me at all. Need the rule, apply the facts, come to a conclusion. Under, here, therefore.
And this is something I think you talked about, in the webinar today, which is practice is also really helpful here, right? So seeing different types of fact patterns, different variations of fact patterns, the more practice you do, the more you sort of train yourself to recognize these patterns upon patterns, and that helps you be able to do that more effectively.
Completely agree, Sam. And let me just throw in a point on this. When I was in law school, I was vexed by this because I thought, gosh, I should be going over my outline. I should be studying the material and not doing questions. Wrong. Doing questions after you've outlined the stuff, doing questions, you are reviewing the material.
Great study.
It's a brilliant thing to do. And you know what? It's like sports. You play like you practice. You play like you practice. And I got to tell you, do those practice exams, you also go in there with some confidence. I know how to handle a 30-minute essay question. I know. Yes, absolutely.
So let's talk a little bit about outlines. We talked about it in the webinar. This person asks, your ability to distill information is beyond admirable. Have you always had that skill, or is there something you can recommend we practice so that we don't get lost in the weeds? This is a question that I know so many 1Ls have, which
is a great question.
Is a great question.
That's part of the art of studying in law school. And it's going to be a little different for everybody. Look, one reason I'm pretty good at it is that I've been doing it for a long time. This is where I think it's important for you to believe in yourself, do this, but study aids and office hours are really important. And I could say, for example, not to hype my own, but in the West Academic Series, there's a series of short and happy guides. And I wrote the Civ Pro one. And the point of that short and happy guide is to do exactly that. Put it in the context that, where does this fit? Where does that fit? Because I think in Civ Pro, one of the dilemmas is I don't see how it fits together. It actually fits together very well. A whole bunch of the courses about, are we in the right court? Personal jurisdiction, subject matter, venue, service of process goes with that. And then the whole bunch of the courses, once we're in the court, how do we litigate? Well, that's all the pleadings and discovery and all that stuff. Study aids can be helpful. And let me mention again the 1L success, the 1L success program, videos, lectures, practice exams, etc. But distilling is hard. And I will tell you this, I have my outlines from law school. They do not look like this. They're much wordier. And that's fine. That's fine. There's no right or wrong way to do this. Just so you do it. Just so you
That's the key, right? And I mean, it's not just getting the final product that's important. It's the process of getting to the final product and knowing that you're not going to do it in one fell swoop and it's done. It's going to be a sort of iterative process over time.
Oh, completely agree. And so I would have classmates say, gee, can I look at your outline? And somehow I knew this. I said, sure, you can look at my outline. The value of your outline is not reading it. The value of your outline is writing it. Because you are not going to put anything down there till you understand it.
Yep.
Bingo.
Great advice. That's great advice. Someone's asking, in terms of keeping up in class, right? Lecture, do you have any suggestions about some really effective strategies for making sure that you're getting what you need to out of class? And specifically, do you recommend handwriting notes or using a computer and typing notes?
Well, that's great. It is all great. I know some of my colleagues in the civil procedure world do not allow computers in the classroom. I do. I do notice that a whole bunch of folks still take notes the old-fashioned way. I happen to be a handwriting guy mostly, but yeah, I mean, it's easier. The problem with taking notes on a computer is that the temptation is to become a court reporter and you just write everything down. Classroom is a lot of work. Even though it's passive for you, the professor's doing most of the work. Um, Even though it's passive in that sense, you ought to come out of class somewhat tired because you are listening to everything. And the thing is, wow, is that important? Oh, here's a fact pattern. How does that fly? That's why I think taking 5 minutes after class is not a bad idea. But it's an art form. Absolutely. Every time you get a fact pattern from the prof, you write that down. That's possibly solid gold. One other thing on practice essays, I just happened into this as a first year. It was great. Do it with a friend. So I had a buddy, and he and I on Saturday mornings would go over to the library. There'd be old exam questions on file. And they back in my day, there were a whole bunch of 45-minute essays. So it was in contracts. And it was Saturday morning, and we got a copy of this question. And he sat there and I sat there. We both had, back then we hand wrote the answers. So we had paper and we had scratch paper to outline our answers. Do not talk to each other. You put the clock for 45 minutes. Then you're done. Now you can talk. Read each other's answer. Oh, it's the best because you will have seen stuff that she didn't see. She will have seen stuff that you didn't see. And you know what? You both really did very, very well. That's why you walk out of exams, everybody says, don't talk about the exam, don't talk about the exam. But you get about, I don't know, 30 steps down the sidewalk going out to dinner, and somebody says, did you see that issue about blah, blah, blah? And then you're off to the races. And it makes everybody feel bad because somebody saw something I didn't. Guess what? You both did great because nobody gets it all.
I second that. I think I ruined my winter break after my first semester exams from that exact same scenario. And I thought I didn't cover like half of the issues in my contract exams. Turns out I did quite well. It was all fine. Many ways you can earn points on these exams.
Exactly. Exactly.
So someone is asking a specific question in terms of exam writing. How do you deal with counter arguments in an issue spotter question? How do you evaluate them?
Nice. Yes, that's in the ambiguity area. This is personal jurisdiction under shoe. This is duty breach, blah, blah, blah. Proximate cause. Realize that what you labor on over all this time is something the prof is going to read and grade in a matter of a few minutes. So what you want to do is demonstrate to the professor that, again, you just do the IRAC. You state the rule. And when you're applying the facts, if it's an ambiguous area, you simply have to say, gosh, you know, this is a lot like the X case, but it's different because in the X case, this fact was different. So arguing it one way, blah, 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 arguing it the other way, blah, 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 and then come to a reasonable conclusion. No prof is going to count you down for coming to a conclusion that the prof didn't come to. Show that. Don't be afraid. Don't be afraid of ambiguity. It is a chance to show off. And I just think you have to seize it. I just think going in aggressively, you know, it's hard not to be scared. Yeah, of course you're scared. But if you've done this and realize your outline, it's not an end in itself. You don't get a grade on your outline. The point of the outline is that it has helped you so that stuff you studied 10 weeks ago, you don't have to go back and relearn it. You did it. And you wrote it down in 2, 3, 4, whatever pages. And now you read that, you've done the heavy lifting. So it's all to help you.
So along those lines of outline and specifically test taking in an open book exam environment, what are your recommendations to students? Do they bring in their full outline? Do you recommend they create something that's a little bit different? Do you recommend they go in with a closed book exam mindset? What are your recommendations there?
I really think the best way to approach it is assume it's closed book, and realize the security blanket that something is there if you need it. But if you say, gosh, okay, blah, 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 it's, oh gosh, Is it 90 days or is it 45 days? Yeah, look that up. Look that up. But if you go in there thinking you're going to look up answers to stuff, not going to work much. I had a prof, this was a great exam. The professor, it's an open book, and it was 9 20-minute questions. Well, you're moving so fast, there's no way you're going to look anything up. But I think most people with an open book, it's really allow the security blanket that, look, there's a lot of stuff to remember. And I think, again, if you've done the outline, you have that in a much more distilled fashion. I actually, later in my law school career, I did the outline, and then I realized, well, heck, I can reduce this really to bullet points. There were no bullet points then because we all wrote with quill pens when I was in law school. But anyway, you get the idea.
And a lot of students find that sort of attack outline approach of moving their outline, condensing it down, and
Exactly.
putting something short in.
And in fact, that's right. Attack outline is kind of what we had in this handout on the diversity jurisdiction. And again, everybody's outline is going to look different, but you're comfortable with it. That's the point.
That's exactly right. Some more questions coming in just about where you can find resources, practice questions. As Dean Freer mentioned, the BARBRI 1L Success Program. We have lots of practice questions, multiple choice essays in there. And then, of course, West Academic Study Aids collection, myriad of resources available to you, practice questions.
And I must say, the 1L Success includes lectures, and I'm blessed to do the civil procedure lecture. And the goal there is simply to lay it out. Just lay it out. And on the PJ part of personal jurisdiction part of it, it's rather lengthy. You might say, oh, I don't want to listen to this guy for that. But the goal is to go through all these cases. And personal jurisdiction is tough because you really have to learn the historical development. Your goal ultimately is to answer the question as of this year. But I don't think you can do that without knowing this flow of cases. And at the end of that, I promise, what I do is bring it back to an analytical framework. And what does it look like? It looks a heck of a lot like our little thing with the hypo, where it's contact, relatedness, fairness.
Excellent. I'm going to blend two questions in our final question here and throw them at you. One is going to make you happy as a civil procedure professor. But someone's asking sort of advice as to how to internalize, how to really memorize and understand these rules, all the rules that someone needs to know, with a specific civil procedure question coming at you. Can you provide us with a quick hypo for removal and remand using your casebook right now, Dean Freer?
Sure. So we have a citizen of Georgia sues a citizen of Tennessee for $100,000 and sues in state court in Tennessee. Okay, it's in state court. Now, state courts can hear any kind of case, basically, right? Federal courts can only hear certain kinds of cases, diversity, federal question. So here's this Tennessee defendant, and he's sitting there in state court in Tennessee, and he decides, gee, I'm the hometown guy, but you know what? I'm not really wild about the state court judge here because this is a neighbor or whatever. I'd rather be in federal court. Can that defendant remove? And the answer is, well, generally you can remove if what? If there's federal subject matter jurisdiction. Well, is there? Sure, there's diversity. It's Georgia versus Tennessee, more than $75,000. So yeah, we can remove, but what's going to happen to the case? It's going to get remanded. Why? Remember, when you remove, you don't have to get anybody's permission. You just do it. It's Nike. You just do it, you know? You don't have to get permission. So now you're in federal court, but you do not belong there, even though there's diversity. Why? Because the defendant was a citizen of the forum. And there is a limitation, even though that's a diversity case. The general rule is you cannot remove a diversity case if any defendant's a citizen of the forum. That's what we have here. That case should be remanded. So it's fun. I mean, it's fun stuff. And I'm promising you, if you listen to the 1L success stuff, if you go through the materials, that's really what that's about.
It's really osmosis. And we cannot emphasize enough, I know you agree with me, Dean Freer, on this, that practice is not just about testing yourself. It's a vital way to learn. It's a vital way to learn these rules because you can see these rules applied to problems. You can see the types of facts that implicate the rules. And all of that study really helps you build the understanding that you need to be successful on your
May I
exam.
jump in with one last thing? I know it's getting
Please.
late, but here's what I say. You might have a hybrid exam, meaning some multiple choice, some essay. Use that to your advantage, because multiple choice, there's got to be a right answer. I mean, there just has to be a right answer or a best answer. So the kind of mechanical stuff, the kind of stuff about, how old's the process server, blah, 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 that is absolute grist for the multiple choice. It may show up on an essay too. You never know. But go in knowing that you're probably not going to get a tough international shoe PJ issue in multiple choice. I mean, it's just hard to come up with one. And that's why on the multi-state bar exam, multiple choice and Civ Pro, the PJ questions you get are pretty straightforward. The tough stuff, like what we just did, shoe, that's going to be essay. Show off, use it to show off, walk them through, but relentlessly mechanical. Because notice, personal jurisdiction's amorphous. Yeah, that's all the more reason you got to have an analytical framework. And the analytical framework is exactly what we have with the horse hypo. Boom, contact, purposeful element, foreseeability. Boom, relatedness. Is it specific? Is it general? Boom, if it's specific, what are the fairness factors? So it's amorphous. Yeah. The answer is usually not clear. Yeah. But by golly, you have a mechanical approach. Keep it mechanical.
Great advice. Excellent. Thank you so much.
Had a great time. Thank you.
And thank you all for joining us, and keep a lookout. More webinars like this to come. Have a great rest of your afternoon. Bye, everybody.
Thank you all.